on the how should the court rule on the defendant's motion to suppress? Motion to suppress. I'm going to read just a little bit above. The parties have stipulated that the woman's conduct in downloading photos from the defendant's computer violated the interception statute. A, deny it as, excuse me. A, deny it as to all photos. B, grant it as to all photos because the woman acted without probable cause. C, grant it as to all photos because the woman violated the federal interception statute. D, grant it only as to the second set of photos. I don't know much. I don't think I'm going to strike anything. The only thing I can see is woman and maybe probable cause.
Why you strike B? Why you think B is wrong?
I mean, unless the woman's an agent of the police, then, I mean, who cares? If it,
Why you didn't strike it?
Okay, well, striking it.
What about C?
Granted as to all photos because the woman violated the federal, I don't think she can violate it. So I'm going to scratch that out too.
What is a federal interception statute?
The federal interception statute, I don't know, to be honest.
That why you should strike it.
Okay. Gotcha.
Go ahead.
So a woman who is a computer whiz decided to dictate herself to exposing persons who traffic in child pornography. So child pornography. She posted a number of sexual-oriented photos on her website. The file for each photo contained an emblem Trojan horse program. The defendant downloaded one of those photos onto his personal computer. Using the embedded program, the woman entered the defendant's computer and found a file containing a pornographic photograph of a child. She copied the file and turned it over to federal law enforcement agency. A federal agent told her that a successful prosecution would require more than one photograph and offered her a monetary reward for additional photos leading to a conviction of the defendant. The woman entered the defendant's computer again, and this time she found hundreds of child pornography photos, which she turned over to the federal agency. The defendant is charged with multiple counts of violating federal statutes. Regarding child pornography. He moves to suppress the photographs that the woman discovered on his computer. The motion is based on both the Fourth Amendment and the federal statute forbidding interception of electronic communication without permission. The parties have stipulated that the woman's conduct in downloading photos from the defendant's computer violated the interception statute. How should the court rule on the defendant's motion to suppress? Deny it as to all photos, granted only as to the second. I'm going to say that the first part was okay because she did it on her own volition, and I'm going to pick D because after she talked to the federal agents, she was acting as an agent and she got paid for additional photos. So I'm going to say that she was an agent of the federal agent. So D. Yay. D, because authorities encouraged and offered to reward the second computer search. The woman was acting as a government agent with regard to that search, which did not, in fact, violate the Fourth Amendment because it was conducted without a warrant. See U.S. Jared, describing relevant conditions and finding on facts less compelling than these, that private hacker was not government agent.
Okay. The only thing I have to complain for today is I go, when B was reading, I go, uh-oh. Why I go, uh-oh? She was flying through A, B, and C, D. She was flying through it. She didn't pause. She did not look at term of art. She didn't think about the title of the woman. You know, she didn't do it. She go, da, 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 and then I knew it. She's not going to be able to strike any of it. So slow down when you try to strike. You know, a lot of time I told you, this here could be true, but this here could be false, right? Or this word is good, but it doesn't connect with this word, for example. You see what I'm saying? She was flying through it. Okay, and that's not how you can strike it. So take it easy when you try to strike.
Okay.
Now, it's very good that once she say that, oh, this woman, she read here somewhere, this woman is an agent. This woman is an agent. So once he has an agent, she had to have probable cause to search. You see it? So that's why the woman probable cause. Now, also, the word probable cause, normally they go with the word policeman. Okay, then normally they go with the word police. The bar examiner would not lie to you. Okay, if they want you to test your probable cause, they're gonna get a policeman involved. Number two, if you have paid attention, okay, to the reading, there was one time they're talking about a statute of interception. If they just mention it, one little bitty sentence, the federal interception statute would not be an answer. Because when they want to test you something, they need facts. They need the whole thing here so you can marinate it. You're not going to be able to marinate when it's only one little bitty sentence about a federal statute. You guys see that? So don't forget that. When you read something, it's just like a blip, and then they mention it. It cannot be the answer. It cannot be the best answer. So that's, learn a little bit. This set of questions is a little bit different. Okay, but she was able to strike B and C, and then she goes. After she read the thing, she was able to strike A. Right, and then so only D left. Okay. Is anybody have any question for me? Was there anybody were able to come up with D? Or was B reading too fast? Okay. If you think B is reading too fast, then you're not quite mastering my method yet.